Today, we're talking about something that almost always gets addressed too late, US immigration law. When foreign companies decide to enter the US market, whether by opening a subsidiary or transferring a key manager or acquiring a local business, immigration tends to land at the bottom of the list. And the priority is the corporate structure, the contracts, and taxes, but immigration gets handled often when the employee is already almost on board on the plane. And that's, of course, a mistake. And that's exactly what we're going to unpack today with Mike Sevilla, an attorney in our Legalmondo network based in Minneapolis, Minnesota. Mike focuses exclusively on US immigration law, work visas, permanent residence, labor certification, and increasingly helping companies navigate federal enforcement actions and employment compliance audits. Mike, welcome. I'm really glad to have you here.
Thank you, Roberto. I'm very excited to chat with you about U.S. immigration law. I think the more people know, the better they can handle these issues. And if you have enough kind of runway, you can really kind of make a smooth transition for your employees. A lot of folks that you're wanting to transfer are pretty critical employees, and so you want to make sure they have that smooth runway.
Okay, fantastic. So let's start from the very beginning. When a non-US company is expanding into the US, what are the immigration issues they should be flagging before the very first employee is transferred?
Yeah, well, one thing that you kind of mentioned in your intro there is corporate structure is really important for certain visa classifications. There's a variety of visa options. It really is just a balancing of priorities for an employer and the employee, really. You want to make sure that there's alignment on both sides. As you mentioned, the corporate structure is usually handled, and then the immigration considerations come in after the fact. We've seen the most success when we've been looped in, especially with smaller companies at that outset with the corporate structure, just to make sure that it's being set up in a way that's going to lend itself to really facilitate transfers from the foreign office to the U.S. office. And so there's, it's not a entirely complex way to kind of set it up, but just a little bit of foresight goes a long way. I think the other thing is, just identifying, are there any treaties in place? There are quite a few options for certain countries that facilitate, investors or traders to set up offices in the U.S. and transfer not only the investors and the sort of folks that are starting the companies, but also essential employees. So just identifying, the corporate structure there as well is really important. And as I mentioned, thinking about the employee as well. Do they plan to stay long term? Does the company want them to stay long term? Is that something that's being considered? There are ways to structure sort of the initial petitions to set them up for an easier pathway to green cards, if that's what's sort of the ultimate goal. And so all of that consideration is really important when you're thinking about, the company side of things, setting up the right entities, making sure the relationships exist with the foreign company, but also just the employees' plans in terms of what their long-term plans are.
Okay. Now, in your experience, and I'm sure you see this often, what are the most common situations where a non-US company suddenly realizes it needs a US immigration counsel?
Often,
What triggers that call?
yeah, yeah. So, we're not unaware of the B1 entries, the ESTA entries, where there's quite a few permissible activities that are included within that. There's a lot of gray area. There are about 8 listed permissible activities, but it's a non-exhaustive list. So oftentimes we'll receive a call after someone's been stopped by CBP and questioned pretty intensely. And so that's where we jump in to one, identify whether the, the stop by CBP was appropriate, and if the activities that they're conducting are sort of in line with the B1 ESTA. And if not, then we sort of try and put together a alternative solution for them that gives them more secure work authorization in the US. And it's a delicate balance because I think the B1 and ESTA are really useful tools. And, if the activities that are being utilized by our clients' employees, then I think that's an absolutely fantastic tool. And it's really straightforward and doesn't require an attorney. ESTA is pretty straightforward. You can apply online. It has the same permissible activities under the B1. The only issue is it's valid for only 90 days upon entry. So that can cause some constraints if you're looking for more long-term, activity in the U.S. But the activities really are limited. It's consulting with associates, it's trainings, things along those lines. It's really meant to um, you know, protect U.S. workers. We don't, the U.S. government doesn't want folks coming in and kind of doing the job of someone who could handle it in the U.S. The primary benefit of the
Yeah.
activity in the U.S. for those folks on STAR B1 must be the foreign entity. So it's an important distinction when you're kind of trying to assess whether the activities are permissible. So that really kicks off a lot of the calls that we take when we're kind of thinking about this after the fact. And so then we start looking at the corporate structure. The L1 visa is a really, really good visa option for a lot of folks, especially for companies that have established presence outside of the U.S. Because really it's just establishing a relationship between any foreign entity and a U.S. entity that creates a sort of bridge that enables you
Yep.
to transfer executive, managerial, or specialized knowledge employees. So executive and managerial, kind of self-explanatory. Executives are folks who are, operating at the top levels, directing sort of, enterprise-wide, initiatives. Managers are the folks who are overseeing, you know,
Mhm.
direct reports and indirect reports. Specialized knowledge employees, that's kind of where it gets a little, more into the gray area. What does specialized knowledge mean? Well, really, it means something that is, typically requiring at least a bachelor's degree or some sort of specialized training for the position. And so that's where we focus on the complexity of the role, the special skills that it takes, perhaps, longevity with the company, in the foreign country to demonstrate that the individual does have specialized knowledge. So, evaluating those things after the fact can create some wrinkles, right? And so kind of going back to our last point, just if we're thinking about it at the outset, then it just creates it enables you to plan. And when you plan, you're going to sort of avoid some of the headaches that can arise if you forgot to plan.
Yeah, it's all about prevention and mitigation of litigation risks, or in this case, compliance. So,
Exactly.
thanks. And let's get into the, let's say, operational side. And what are the most common mistakes you see non-US employers make, especially when they are transferring executives or managers, engineers, or other key personnel to the US?
Yeah. So it really goes back to that corporate structure. It's one of the linchpins of that L1 visa. So the L1 visa, like I said, is what sort of um, you know, connects the dots between the foreign entity and the U.S. entity. And so um, you may have someone who's operating a very key role abroad, but if the company structure isn't properly aligned, then you're going to have to do some sort of work after the fact that's going to be costly to sort of rearrange the corporate structure in order to facilitate that transfer. So if sometimes that happens. Sometimes you weren't thinking about sort of the launch into the US market. But if you have a vision of launching to the US in, a year, 2, 3 years, it really is worth it to just sort of pick up the phone, spend the 10 minutes talking to a US immigration lawyer to just cover that base and see, what that legwork is at the front end, because setting it up after the fact would be a lot more cumbersome than just having that 10-minute call to set it up. And I'm working with a couple of different clients right now. One's in London, and they're a technology company. And I mean, you rarely see this. They reached out to me 2 years before they want to sort of enter the U.S. market, and so they're really, really thinking about strategy. And not only are they thinking about the corporate structure, they're wanting to make sure that their employees have, really, really strong cases for these different sort of categories in terms of executive managerial. So they're asking me, what are the criteria? How do we make sure we're setting up their roles sort of right now as we start our company in the UK so that they can get set up in the US? And so that's, kudos to them for the foresight. And I understand that it's not something that's going to happen on a regular basis, but that's really going to set them up for immense success. And I mean, not only that, they're exploring their different options, right? So we're talking about the L1, which is a really strong option, but they're also evaluating the E2 visa, which is one in which, because they're a UK company, there's a treaty between the US and the UK. And so an
Okay.
investor there can set up shop, and as long as we can demonstrate that the investment is substantial and that it'll sort of generate enough money to sort of, cover the expenses of the individual moving into the US, that's a potential opportunity. The nice thing about the E2 is that there isn't a requirement that the employee have worked for the foreign company for a 12-month period. So the L1 is
Okay.
really a transfer for existing foreign employees. Um, and oftentimes, what we'll see is if a company qualifies sort of for the E2, we can also sort of set up in tandem the L1 sort of structure and the E2 so that they can, make key hires. They're recruiting all over the world. So if they have someone, for example, this UK company, if they find someone in the UK that's perfect for a US role, well, they can hire them through that E2 sort of investment visa as an employee without having to have that 12-month, you know, e- work experience with the foreign company. So that becomes a sort of suspenders and belt type strategy where you're kind of covering all bases and really setting your company up to facilitate transfer of sort of all kinds of talent to the US.
I see. Now, timeline. Companies assume that it's a matter of weeks, I guess. And but what is a realistic timeline for the main visa categories that companies deal with?
Yeah, and it's interesting. I really pride myself on trying to streamline the process. We use technology within our practice to sort of make hires as seamless as possible. I understand that when you're sort of evaluating the hire, like when you're in the US and you're a US company, you're setting that company up, you can hire US workers sort of on the spot, right? It takes a lot longer to sort of onboard someone who needs work authorization. So we really try and streamline that. And when we have sort of experience with a company and we've done sort of the L1 visa before, we can do that within 4 to 6 weeks. So it is a pretty quick
Okay.
process. The initial one it is quite a bit longer. I would say probably 10 to 16 weeks, just depending on how organized the company is.
Okay.
And then, one other thing I wanted to touch on is with the L1 visa, there's a concept called blanket L. And so the conversation that we've had is about kind of the relationship between the different entities, right? Well, we can sort of
Yeah.
essentially get the relationships between multinational companies, like with all of their entities, pre-approved from immigration. And what that enables an employer to do is sort of have this pre-approval. So every time they want to send someone to the US, they don't have to address the relationship component of the foreign entity to the US entity. um,
Okay.
they can just focus on the qualifications of the employee in that executive managerial or specialized knowledge. component, and they can sort of go directly to the consulate and apply at the consulate versus having to get a pre-approval in the US to then go to the consulate. So it's one of the really nice functions of the L1 visa. It's always been contemplated as this visa to really facilitate intercompany transfer between, multinational companies, to really transfer their employees. And there are some prerequisites of setting up the blanket. You have to have either 1,000 employees, $25 million in US
Okay.
revenue, or at least 10 L1 visas approved for the company. So it's not for startups per se, but sort of that mid-market. We're looking at, more of an opportunity there. And certainly for very large companies who are trying to enter the US market, it could sort of be a little bit more viable in that regard if they have US sales.
I see. So let me ask you about a scenario that comes up more and more in our practice,
Sure.
which is cross-border M&A transactions or corporate restructurings. How does US immigration affect those deals? And is it something that typically gets flagged in the due diligence or not?
Yeah, good question. I think as of late, it's become more of a issue that is worthwhile to buyers. They are wanting to see, you know, compliance in terms of the US sort of, you know, I-9 compliance, really. But they also want to make sure that, key employees' work authorization is going to be transferable, and sort of wanting to assess what the sort of contingencies that need to be addressed in that regard. So it's certainly become a much bigger issue, as you've probably seen during, transactions. It's sort of an afterthought. It's part of the labor and employment due diligence, but it's sort of its own, it's probably one or two questions on a due diligence spreadsheet there, but it's something that buyers have focused significantly more on, just given the current administration's focus on immigration. And on two fronts, right? When you're taking on I-9s, which are sort of, just by way of background, they're a form that every employer in the US has to complete to verify that an employee has valid work authorization. So it's intended to prevent employers from sort of hiring undocumented workers. And so there are significant fines that can come into place, if an employer is not compliant with the I-9. And so those liabilities will transfer under, various scenarios to a buyer of an organization. So because we're seeing a lot of enforcement action under this administration, it's definitely flagged more often and explored. And so, I've been on a couple of deals, really interesting deals. So I work a lot with our U.S. China practice group, and with the
Mhm.
One Big Beautiful Bill Act, we saw a transition of tax credits for renewable energy. And so we do a lot of work with solar manufacturing. And so we had to really evaluate how to sort of navigate a transaction where we're sort of, disinvesting, and but still maintaining the ability to bring Chinese workers in, and with that under the L1 structure. So that was a really fun, complex project to navigate on a very large scale. So it's something that we're it's keeping us on our toes, but it's been fun, challenging development within the practice that I've really enjoyed kind of exploring and diving into.
Okay, so let's say ideally immigration counsel should be at the M&A table alongside transactional counsels and not brought in after closing.
Yeah, right, exactly.
Yeah. So, Mike, I'd like to close this conversation with a real world example, something you've actually handled. Can you share a case where early coordination between a foreign counsel or, I don't know, a CEO or a CFO And the US Immigration Council made a real difference. So something that saved the client a significant time, cost, or even avoided business disruption.
Yeah, absolutely. And so, I mentioned the UK company that I'm working with, but there's another company as well that I'm working with, and this is actually a client from South Africa, and um, they develop medical devices, and so they were also sort of thinking about their US launch and had an idea of a corporate structure that worked from a sort of tax perspective and an IP perspective because of how they wanted to sort of house the IP within the US. And we had a conversation about the challenges, the way the corporate structure would, impact their ability to transfer employees. And so we made a couple small shifts in terms of that corporate structure. And now they sort of you know, get the best of both worlds. They have their tax and IP considerations addressed while still maintaining that flexibility to allow the transfers. And so that's a really concrete example of sort of getting in early before you've actually set up the entity in the US to sort of facilitate that you know kind of holistic perspective of the company to execute all of its different goals, right? Because the entity is, the key employees are the owners as well. So they're really,
Mhm.
wanting to make this, system set up for all of their own personal goals as well. And so it's um,
Yeah.
maybe because there's so much stake in it for them, they've considered that, immigration component that's usually sort of not considered. But that was one example where we were able to save the company a lot of money in terms of just a 30-minute call enabled them to set up the right structure and preserve really the bigger considerations of that IP and tax facilitation.